And we're starting in 3, 2, 1. Welcome back to Epstein Files Review, episode 90. As always, this is an 18 and up channel, so if you're under the age of 18, we're going to have to ask you to leave. And with that being said, we're going to jump right back down the rabbit hole. We're going to start with a recap of our last file, which was file 8999. This is just a factual background, and they were using this to prove that Ghislaine Maxwell, there she is right there, committed perjury. So we'll just jump right into the next file because it's a lot of verbiage. Beginning in at least 1994, Ghislaine Maxwell, the defendant, enticed and groomed multiple minor girls to engage in you-know-what acts with Jeffrey Epstein through a variety of means and methods, including but not limited to the following. Maxwell first attempted to befriend some of Epstein's minor victims prior to their abuse, including by asking the victims about their lives, their schools, and their families. Maxwell and Epstein would spend time building friendships with minor victims by, for example, taking minor victims to the movies or shopping. Some of these outings would involve Maxwell and Epstein spending time together with a minor victim, while some would involve Maxwell or Epstein spending time alone with a minor victim. Having developed a rapport with the victim, Maxwell would try to normalize you-know-what abuse for a minor victim by, among other things, discussing you-know-what topics, undressing in front of the victims, being present when a minor victim was undressed, and or being present for you-know-what acts involving the minor victim and Epstein. Maxwell's presence during minor victims' interactions with Epstein, including interactions where the minor victim was undressed or that involved you-know-what acts with Epstein, helped put the victims at ease because an adult woman was present. For example, in some instances, Maxwell would massage Epstein in front of a minor victim. In other instances, Maxwell encouraged minor victims to provide massages to Epstein, including you-know-what massages, during which a minor victim would be fully or partially nude. Many of those massages resulted in Epstein you-know-whatting the minor victims. In addition, Epstein offered to help some minor victims by paying for travel and or educational opportunities, and Maxwell encouraged certain victims to accept Epstein's assistance. As a result, victims were made to feel indebted and believed that Maxwell and Epstein were trying to help them. Through this process, Maxwell and Epstein enticed victims to engage in you-know-what activity with Epstein. In some instances, Maxwell was present for and participated in the you-know-what abuse of minor victims. Some such incidents occurred in the context of massages, which developed into you-know-what encounters. Ghislaine Maxwell, the defendant, facilitated Jeffrey Epstein's access to minor victims, knowing that he had a you-know-what preference for underage girls and that he intended to engage in you-know-what activity with those victims. Epstein's resulting abuse of minor victims included, among other things, touching a touching a victim's you-know-whats, placing a you-know-what, such as a you-know-what, on a victim's you-know-what, directing a victim to touch Epstein while he you-know-whatted, and directing a victim to touch Epstein's you-know-what. Maxwell and Epstein's victims between approximately in or about 1994 and in or about 1997. Ghislaine Maxwell, the defendant, facilitated Jeffrey Epstein's access to minor victims by, among other things, inducing and enticing and aiding and abetting the inducement and enticement of multiple minor victims. Victims were groomed and or abused at multiple locations, including the following: a multi-story private residence on the Upper East Side of Manhattan, New York, owned by Epstein, the New York residence, which is depicted in the following photograph. There it is. And a estate in Palm Beach, Florida, owned by Epstein, the Palm Beach residence, which is depicted in the following photograph. There it is once again. And a ranch in Santa Fe, New Mexico, owned by Epstein, the New Mexico residence, which is depicted in the following photograph. Maxwell's personal residence in London, England. Among the victims induced or enticed by Ghislaine Maxwell, the defendant, were minor victims identified herein as minor victim 1, minor victim 2, and minor victim 3. In particular, and during time periods relevant to this indictment, Maxwell engaged in the following acts, among others, with respect to minor victims. Maxwell met minor victim 1 when minor victim 1 was approximately 14 years old. Maxwell subsequently interacted with minor victim 1 on multiple occasions at Epstein's residences, knowing that minor victim 1 was under the age of 18 at the time. During these interactions, which took place between approximately 1994 and 1997, Maxwell groomed minor victim 1 to engage in you-know-what acts with Epstein through multiple means. First, Maxwell and Epstein attempted to befriend minor victim 1, taking her to the movies and on shopping trips. Maxwell also asked minor victim 1 about school, her classes, her family, and other aspects of her life. Maxwell then sought to normalize inappropriate and abusive conduct by, among other things, undressing in front of minor victim 1 and being present when minor victim 1 undressed in front of Epstein. Within the first year after Maxwell and Epstein met minor victim 1, Epstein began minor victim 1, abusing minor victim 1. Maxwell was present for and involved in some of this abuse. In particular, Maxwell involved minor victim 1 in group massages of Epstein. During those group massages, Maxwell and or minor victim 1 would engage in acts with Epstein. Epstein and Maxwell both encouraged minor victim 1 to travel to Epstein's residences in both New York and Florida. As a result, minor victim 1 was abused by Epstein in both New York and Florida. Minor victim 1 was enticed to travel across state lines for the purpose of encounters with Epstein, and Maxwell was aware that Epstein engaged in activity with minor victim 1 after minor victim 1 traveled to Epstein's properties, including in the context of a massage. Maxwell interacted with minor victim 2 on at least one occasion in or about 1996 at Epstein's residence in New Mexico, when minor victim 2 was under the age of 18. Minor victim 2 had flown into New Mexico from out of state at Epstein's invitation for the purpose of being groomed for and or subjected to acts of abuse. Maxwell knew that minor victim 2 was under the age of 18 at the time. While in New Mexico, Maxwell and Epstein took minor victim 2 to a movie, and Maxwell took minor victim 2 shopping. Maxwell also discussed minor victim 2's school, classes, and family with minor victim 2. In New Mexico, Maxwell began her efforts to groom minor victim 2 for abuse by Epstein by, among other things, providing an unsolicited massage to minor victim 2, during which minor victim 2 was topless. Maxwell also encouraged minor victim 2 to massage Epstein. Maxwell groomed and befriended minor victim 3 in London, England between approximately 1994 and 1995, including during a period of time in which Maxwell knew that minor victim 3 was under the age of 18. Among other things, Maxwell discussed minor victim 3's life and family with minor victim 3. Maxwell introduced minor victim 3 to Epstein and arranged for multiple interactions between minor victim 3 and Epstein. During those interactions, Maxwell encouraged minor victim 3 to massage Epstein, knowing that Epstein would engage in acts with minor victim 3 during those massages. Minor victim 3 provided Epstein with the requested massages, and during those massages, Epstein abused minor victim 3. Maxwell was aware that Epstein engaged in activity with minor victim 3 on multiple occasions, including at times when minor victim 3 was under the age of 18, including in the context of a massage. Maxwell's efforts to conceal her conduct. In or around 2016, in the context of a deposition as part of civil litigation, Ghislaine Maxwell, the defendant, repeatedly provided false and perjurious statements under oath regarding, among other subjects, her role in facilitating the abuse of minor victims by Jeffrey Epstein, including some of the specific events and acts of abuse detailed above. Statutory allegations from at least in or about 1994 up to and including in or about 1997 in the Southern District of New York and elsewhere, Ghislaine Maxwell, the defendant, Jeffrey Epstein, and others, known and unknown, willfully and knowingly did combine, conspire, confederate, and agree together and with each other to commit an offense against the United States, to wit, enticement in violation of Title 18, United States Code Section 2422. It was a part and object of the conspiracy that Ghislaine Maxwell, the defendant, Jeffrey Epstein, and others, known and unknown, would and did knowingly persuade, induce, and coerce one and more individuals to travel in interstate and foreign commerce to engage in activity for which a person can be charged with a criminal offense in violation of Title 18, United States Code Section 2422. Overt acts. In furtherance of the conspiracy and to effect the illegal object thereof, the following overt acts, among others, were committed in the Southern District of New York and elsewhere. Between in or about 1994 and in or about 1997, when minor victim 1 was under the age of 18, Maxwell participated in multiple group encounters with Epstein and minor victim 1 in New York and Florida. In or about 1996, when minor victim 1 was under the age of 18, minor victim 1 was enticed to travel from Florida to New York for purposes of abusing her at the New York residence in violation of New York Penal Law Section 13055. In or about 1996, when minor victim 2 was under the age of 18, Maxwell provided minor victim 2 with an unsolicited massage in New Mexico, during which minor victim 2 was topless. Between in or about 1994 and in or about 1995, when minor victim 3 was under the age of 18, Maxwell encouraged minor victim 3 to provide massages to Epstein in London, England, knowing that Epstein intended to abuse minor victim 3 during those massages. Title 18 United States Code, Section 371. Count 2. Enticement of a minor to travel to engage in illegal you-know-what acts. The grand jury further charges the allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. From at least in or about 1994 up to and including in or about 1997, in the Southern District of New York and elsewhere, Ghislaine Maxwell, the defendant, knowingly did persuade, induce, entice, and coerce an individual to travel in interstate and foreign commerce to engage in you-know-what activity for which a person can be charged with a criminal offense, and attempted to do the same and aided and abetted the same, to wit, Maxwell persuaded, induced, enticed, and coerced minor victim 1 to travel from Florida to New York, on multiple occasions with the intention that minor victim 1 would engage in one or more you-know-what acts with Jeffrey Epstein in violation of New York Penal Law Section 13055, Title 18 United States Code Section 2422 and 2, and Count 3, conspiracy to transport minors with intent to engage in criminal you-know-what activity. The grand jury further charges the allegations contained in paragraph 1 through 8 of this indictment are repeated and realleged as if fully set forth within, from at least in or about 1994 up to and including in or about 1997, in the Southern District of New York and elsewhere, Ghislaine Maxwell, the defendant, Jeffrey Epstein, and others known and unknown willfully and knowingly did combine, conspire, confederate, and agree together and with each other to commit an offense against the United States, to wit, transportation of minors in violation of Title 18, United States Code Section 2423A. It was a part and object of the conspiracy that Ghislaine Maxwell, the defendant, Jeffrey Epstein, and others known and unknown, would and did knowingly transport an individual who had not attained the age of 18 in interstate and foreign commerce with intent that the individual engage in you-know-what activity for which a person could be charged with a criminal offense in violation of Title 18, United States Code Section 2423A. Overt acts in furtherance of the conspiracy and to effect the illegal object thereof. The following overt acts, among others, were committed in the Southern District of New York and elsewhere between in or about 1994 and in or about 1997. When minor victim 1 was under the age of 18, Maxwell participated in multiple group you-know-what encounters with Epstein and minor victim 1 in New York and Florida. In or about 1996, when minor victim 1 was under the age of 18, minor victim 1 was enticed to travel from Florida to New York for purposes of, you-know-what, abusing her at the New York residence in violation of New York Penal Law Section 13055. In or about 1996, when minor victim 2 was under the age of 18, Maxwell provided minor victim 2 with an unsolicited massage in New Mexico, during which minor victim 2 was topless. Between in or about 1994 and in or about 1995, when minor victim 3 was under the age of 18, Maxwell encouraged minor victim 3 to provide massages to Epstein in London, England, knowing that Epstein intended to, you-know-what, abuse minor victim 3 during those massages. Title 18, United States Code Section 371. Count 4, transportation of a minor with intent to engage in criminal you-know-what activity. The grand jury further charges the alleged allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within, from at least in or about 1994 up to and including in or about 1997, in the Southern District of New York and elsewhere, Ghislaine Maxwell, the defendant, knowingly did transport an individual who had not attained the age of 18 in interstate and foreign commerce with the intent that the individual engage in you-know-what activity for which a person can be charged with a criminal offense and attempted to do so, and aided and abetted the same, to wit, Maxwell arranged for minor victim 1 to be transported from Florida to New York, on multiple occasions with the intention that minor victim 1 would engage in one or more you-know-what acts with Jeffrey Epstein in violation of New York Penal Law, Section 13055. Title 18, United States Code Section 2423A and 2. Count 5, perjury. The grand jury further charges the allegations contained in paragraphs 1 through 8 of this indictment as repeated and realleged as if fully set forth within. On or about April 22, 2016, in the Southern District of New York, Ghislaine Maxwell, the defendant, having taken an oath to testify truthfully in a deposition in connection with a case then pending before the United States District Court for the Southern District of New York under docket number 15, Civ 7433, knowingly made false material declarations, to wit, Maxwell gave the following underlying false testimony. Did Jeffrey Epstein have a scheme to recruit underage girls for you-know-what massages? If you know, I don't know what you're talking about. List all the people under the age of 18 that you interacted with at any of Jeffrey's properties. I'm not aware of anybody that I interacted with other than obviously the plaintiff, who was 17 at this point. Title 18, United States Code Section 1623, Count 6, perjury. The grand jury further charges the allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. On or about July 22nd, 2016, in the Southern District of New York, Ghislaine Maxwell, the defendant, having taken an oath to testify truthfully in a deposition in connection with a case then pending before the United States District Court for the Southern District of New York under docket number 15, Civ 7433, knowingly made false material declarations, to wit, Maxwell gave the following underlying false testimony. Were you aware of the presence of you-know-what toys or devices used in you-know-what activities in Mr. Epstein's Palm Beach house? No, not that I recall. Do you know whether Mr. Epstein possessed you-know-what toys or devices used in you-know-what activities? No. Other than yourself and the blonde and brunette that you have identified as having been involved in three-way you-know-what activities, with whom did Mr. Epstein have you-know-what activities? I wasn't aware that he was having you-know-what activities with anyone when I was with him other than myself. I want to be sure that I'm clear. Is it your testimony that in the 90s and 2000s you were not aware that Mr. Epstein was having you-know-what activities with anyone other than yourself and the blonde and brunette on those few occasions when they were involved with you? That is my testimony. That is correct. Is it your testimony that you've never given anybody a massage? I have not given anyone a massage. You never gave Mr. Epstein a massage. Is that your testimony? That is my testimony. You never gave minor victim 2 a massage. Is your testimony? I never gave victim 2 a massage. Title 18, United States Code Section 1623. You've got the acting U.S. Attorney Audrey Strauss's name here. And this was the United States District Court, Southern District of New York, United States of America versus Ghislaine Maxwell, defendant, superseding indictment. And then you have the typed acting United States Attorney's name. Once again, Audrey Strauss. You do not have the foreperson for some reason. So we're going to jump to the next file. We are 16% through this episode. I know a lot of this may seem repetitive, but with the multiple charges, they have to basically list them all out. So it could be a little wordy, but like I always say, for the sake of transparency, all files will be read. So here we have, I guess it says page 200. This is a strange excerpt here, but we're going to read it. Day you were called for some edits that really seemed to reflect a real discomfort. Question as you identify. Again, I'm supporting the point you're trying to make, that we were focused on getting this done and real concern that he would not go to jail. So this looks like some sort of inquiry about most likely Epstein, since it says he would not go to jail, but let's see where this is going. And a question that I think is a valid one in mind is, did the focus on let's just get this done and get a jail term mean that we didn't take a step back and say, let's evaluate how this train is moving? From my perspective, okay, I want to just sort of round out the little bit of this, the state-only resolution. You used the term a couple of times, backstopping. What do you mean by that? What I mean by that is a sense that the state wasn't doing enough, and perhaps backstopping is a polite way of saying encouraging the state to do a little bit more. All right. Did you have any discussions about whether this deposition comported with the Ashcroft memo and that you were hunting to the state for a fairly minor charge, what your office had already understood from the evidence was a quite wide-ranging scheme of predatory, behavior regarding minor victims? So I don't recall a discussion around the Ashcroft memo. I would characterize what we did differently in that there are any number of instances where the federal government or the state government can proceed and state charges are substantially less indifferent. And on a fairly regular basis, the federal government allows the state, but stands aside and lets the state proceed. But in this case, you actually had an active investigation that had been proceeding for a year. So let's take the drug context where there might be any number of active investigations where the federal charges can be rather substantial, but ultimately the federal government says just let the state proceed with this. Or violent crime cases where the federal government could bring gun charges using felon in possession or another mandatory minimum, but the state goes forward with, so in that sense, but the state goes forward with what? Forward with different charges that have a lesser term. And so I don't think it's unusual. We can talk about, whether this was the best disposition or not, but I don't think it's unusual to have fact patterns that are under investigation that proceed in state court, where the disposition is different than and would have been if it had proceeded in federal court. All right, do you have anything on that? On the 2 years or something else? No, I'm going back to the 2 years. Okay. By redacted. Did you believe at the time, if this was part of your thinking, that because it was so important to get sex offender registration, even later developed damages, monetary damages for the victims, under the state plea arrangement, that pretty much the only thing that the federal government had to give up in this negotiation was jail time. If you wanted, right, 3 things, correct. You've said jail time, sex offender status, and some kind of restitution or damage. Right. Mechanism, sex offender registration, there's no give there. You either register or you don't. I'm being binary, right. Again, I'm sorry, but it is binary, so it is binary, yes. And likewise, the right, monetary recovery provisions. So really the only thing to negotiate is time, right? And so your question is, why did we not start at 3, so we ended up at 2? So this sounds like some sort of negotiation between the lawyers and most likely prosecutors in regards to the Jeffrey Epstein case. It looks like they're trying to minimize the damage here, get him as little time as possible, but it seems that him registering as an offender was a non-option, that was just mandatory and customary in this sense, but they're trying to limit how many years in prison he's supposed to do. Well, that's a consequence of what? So I was asking, so again, my recollection is I understood this to reflect that what he would have received as opposed to some arbitrary, let's start at 3, so we end up at 2. I'm sorry, you have a question. No, go ahead, I'll get to my question. I also, from my perspective was, early on when we set firm on the 2 years, I thought 2 years would have been the right outcome. We ended up on 18 months. I can't say how. There's some documents that might help, but I was at least initially firm on those 2 years, right? So when you say I thought the 2 years was the right amount, is that based on your understanding that that's what he would have gotten in the state? Correct. All right. That, and the point I'm trying to convey there is that this wasn't, to my understanding, a random number, but it was informed by this is what he would have received, and therefore it is reasonable. Agree or disagree with the analysis, but it was an informed number to begin with by redacted. But you don't recall how that analysis was done or who conducted. That analysis, don't recall that by redacted, or even whether it was accurate actually. I don't recall that. All right, by redacted, and I understand the explanation, right, and right, what it's tied to, but was there any consideration because this case, right, was not about 1 or 2 victims. It was a very large scheme by this older wealthy man to essentially turn minors into prostitutes, have what with them, get other people involved. You've described it in prior statements as grotesque and deserving of punishment. What I'm not hearing, though, through this process is anybody taking a look at this overall conduct and saying what is the appropriate punishment for this man's conduct. Was there such a consideration, and did you feel that 2 years adequately punished him for the scope of his conduct? Fair question, and perhaps going back to where we started, which is petite. To my mind at the time, there was a distinction between what would be the adequate punishment if this was a purely federal case versus what is necessary so that it is not to put in a petite language, a manifest injustice, so that it wouldn't have to come to the office in the first place. So this is more of like a plea agreement. So they don't have to go through this whole trial, which they ended up doing anyway. I mean, Epstein obviously never got his trial in full because he quote unquote took his own life. And we didn't see any of Ghislaine Maxwell's case. I mean, us seeing these transcripts is the closest we'd get to actually being in that courtroom, because it was not on television. And I'm assuming because all of the people involved and then potentially being implicated, they didn't even want to leave a chance of any prominent figures, because we know Epstein was connected to presidents and all kinds of nobility. They didn't want to even leave it to a chance that one of their names might actually be muttered in court. So it was all behind closed doors. And that, I think, is the important distinction, because if the 2 years is what we would have received, and therefore it would not have come into the office under Petit, then if there is a state deposition to that, that is one possible outcome. So basically they're saying if they can get this as a charge and get the minimum sentence without it being pushed to the press, they would have done that. It would be a different outcome if this was truly a federal prosecution independent of the state, which goes back to the point I was making about concern about a federal precedent, this kind of sentence, because then when the next person comes along, they say, well, here is the president under 371 or whatnot. And so this was rightly or wrongly, and I understand the pushback analysis that distinguish between what is necessary to prevent manifest injustice versus what is the appropriate federal outcome to that. So basically what they're saying is this case is going to set precedents. They can't be too lenient on a sentence, because the next time such an atrocity is committed, they're going to reference this case, and if he gets a light sentence, then everybody's going to get a light sentence. But from between the two people that are talking here, it seems like despite that, they don't want it to be too lenient, but for the defense attorneys, they don't want it to be quote-unquote too harsh. In my personal opinion, there's no such thing as too harsh in consideration of the crimes that have been committed, multiple crimes with multiple women that have been committed by Jeffrey Epstein. But we'll continue. Agree or disagree with the logic is one thing, but did I explain the logic? Yes, you've explained the logic. Okay. And I'm going to push back a little bit on that, because the Petit policy, so they're talking about a policy specifically, states it does not apply where the state conduct is only a minor part, an insignificant part of the entire course of conduct. And they give examples about where you have some type of RICO scheme, and the state has indicted or convicted the perpetrator based on something that could be one single overt act in the government's conspiracy. And doesn't that really show what is going on here? That what the state had done was really just a small minor part of the scheme, that the federal government had a real opportunity to punish him for this entire course of conduct. So possibly, but if I can circle back to your question previously, it's interesting that you characterize this as he's turning these girls into prostitutes. And then I think that's really interesting, because in 2019, 13 years afterwards, despite all the changes in the law, there is still some element somewhere that says he's turning these girls into prostitutes. Whereas this was a typical trafficking case of the kind that you'd see in the Lou DeBaca days, where, it was called modern day slavery. That's a very different fact pattern. So, a girl that's held captive is forced to serve multiple men per day, where this is part of an ongoing business arrangement. So this is a pretty sick lawyer, because he's basically trying to minimize the actions and make it seem like, well, in comparison to barbaric activities of the past, it's not so bad. So this lawyer is despicable, but this is what he's trying to do here. And so I hear what you're saying, but if here at this table at least some element of that characterization is alive, what would it mean in 2006 when these laws are still being developed? So this is 20 years ago. And that consideration, rightly or wrongly, was part of this analysis. Was it explicitly, in other words, was that aspect of it, the perception that this was perhaps activity that in which the victims cooperated, was that part of the let me distinguish. I didn't say the perception that this was activities in which the victims cooperated. What I was going to, I've gone to before is jurors, is there at least one juror that might say, look, we've got conflicting victim testimony. Some of them said he did nothing wrong. They all knew each other. They kept going back and taking payment. Is this trafficking or is this prostitution? I'm not saying I agree with that, and I don't think prosecutors do. I'm saying is there at least a possibility of that? And so this is basically I don't know if this is a tapped call, but it's clearly typed dialogue. This isn't like a stenographer here. This is a conversation that's being written out. That's why you see all these pauses and stutters, because they're interrupting the or should I say interjecting in the conversation, but written it looks like they're interrupting or they're stuttering. Was that articulated to you by the people you were listening to by redacted and so redacted? So that certainly, I don't know why this entire question was redacted. So that certainly was part of the discussions when I talk about the victim issues, but at least some jurors view it that way, rightly or wrongly. And you recall having those conversations. I recall having not only how would the witness stand up in court, but how would jurors view them. And then the second part of that is, and it goes up in the appellate process with respect to the federal nexus. And so I hear you, but it's sort of one of the factors, and so by redacted. And so, yeah, what I'm getting though is that there didn't seem like there was a consideration or discussion about, is this 2 years capturing the scope of his conduct versus we're just going to tie it to this potential state crime that could have been charged. Fair. And I would say that the 2 years was not meant. So the Pettit policy has several prongs into my recollection. The Pettit analysis was not based on, and let's not even call it Pettit analysis, that overstates it. But it was much more of is this a manifest injustice? And if the original, and so you sort of see it in the Exhibit 3, this would not have been brought to the office in the first place. If he had pled to jail time and registration, and rightly or wrongly, that was understood from the very beginning of the case. It was a factor in how the case was viewed. So I do realize that Jeffrey was informed that he had to register, and when he had to register as, and what kind of offender that is, he was reluctant to do so. Why? Because he was in denial, and he didn't consider himself a predator on children. So I can't 12 years later say how we knew that. I can say that my general impression was that this was proceeding at the state, that there were certain charges, and that those charges changed when it went to a grand jury, and that it went from, I think they even changed the ASA involved. We do know they did change the ASA. Redacted, they did, so they admit that as well. The witness, I can't speak for certain, but you probably have that from the record, and that when they changed the ASA involved and took it to grand jury, the charges that came back were substantially less. Now, remember when that detective was pushing for the charges and it was said that he got pulled off the case? The second judge did still pursue charges, but it appears that it was to a lesser degree, which, Jeffrey Epstein and Ghislaine Maxwell and their entire camp were trying to derail the investigation from the beginning, hence why certain witnesses were getting threats and being told not to cooperate. And this was by redacted, of course. Do you remember the circumstances? Did you know the circumstances under which that ASA was changed? I don't know. All right. By the way, do you remember an occasion in which redacted came to your office in Miami to press you on what was going to be happening with the federal case? I don't recall. You don't recall. Just one more. Yeah, the witness. Yeah. So before we, leave this, one little thing. So if this case had come into the federal system apart from the right, taking the digression through the right state system, do you think that the 2 years was an appropriate punishment given the scope of his conduct? So these are all just interjections. I think if it had come into the federal system apart from the whole state and the Pettit considerations and all that, we may have ended up in a different place. I viewed the 2 years, to my recollection, as a manifest injustice standard and not an appropriate punishment standard. So this still looks like testimony, meaning whether it was manifestly unjust that he got 2 years. No, whether it was so, let me rephrase. No jail time was a manifest injustice. If he had gone to jail for 2 years in the state system and registered, the question of whether it would have come to the office at all, and to my recollection, the census was, and redacted, based on Exhibit 3, agrees with that it would never have come to the office in the first place because we would not view that under Pettit as a manifest injustice. There are any number of cases that are prosecuted around the country where an individual gets a jail time that the federal government may not agree with. but that doesn't mean that the federal government re-prosecutes those cases. The instances where the federal government prosecutes a state case are pretty rare, to my knowledge, and so under the state Pettit standard and the Pettit, the manifest injustice would have been a manifest injustice to have 0 jail time and 0 registration. But if the original charges had remained, that would be a different matter. That does not mean that this is the best outcome in the state system. And so, perhaps beating an issue, but let me maybe give an example. One concern that I had was that in the violent crime side, the state brings a case and, there is a deferment, no jail time. The state then brings a second case and there's minimal jail time. Well, now the person has done 3 violent crimes. They have a gun, they go federal, and it's like, please don't do that. Please don't do that. We're going to punish you a little bit. And then all of a sudden, in comes the federal government with the big punch to the face, because the federal sentences are so different than the state sentences. And what happens all the time in any number of contexts in Florida, that doesn't mean that all of those cases get re-prosecuted as a gun case in Florida. That means that we understand that the Florida system is different than the federal system. And so the way we looked at least based on my recollection, those 2 years was not, what would he have received if this was a purely federal case? Or would this case have been prosecuted by the federal system additionally if he had received jail time and registration in the state system? And is it fair to say that the particular concern about, for lack of a better word, federalism or the Pettit policy was that a primary concern of yours versus any of your employees in terms of redacted or redacted? I think it's fair to say that I focused more on the legal side of things and my team focused more on the trial and how this would play out at trial. And both of them sort of informed the outcome. So this looks like, in context, it's some sort of testimony, but it also appears to be like almost the prosecutors and the defense talking things out, trying to come to some form of an understanding. This is a very strange format because we haven't seen these documents before, so it's kind of hard for me to pinpoint. It's obviously not the grand jury, but it is a Q&A format as far as being asked a question and providing an answer. And we'll continue with that. We're about almost 30% through this episode. And you are including this Pettit policy in your consideration of the legal issues? Yes, yeah. I think those are all tied together by redacted. So you mentioned victim, but could I? Yes, but to clarify, thought we had sufficient to go forward, so it wasn't an ethical violation to proceed. Okay, the victim, you mentioned the victims coming to state court. You talked about all the victims coming into state court. Do you have any idea what victims formed the basis for the original charge? That I do not. He was indicted on, do you know whether it was was it a felony assault pros or a non-minor? It could have been. It was 3 instances and to felonize it. You don't know whether it was 1 person, 3 times, 3 people? I do not. No, I do not. And you don't know whether that person was a minor or not? I do not. All right. So basically, this looks like some sort of cover-up as far as trying to make sure that they do not admit to knowing that there were minors involved and not really knowing what the crimes they committed were, or that they were even committing crimes in the first place, which we know is completely bogus. I would assume they were, but I do not. Likewise, do you know who was the victim or who the victims were who formed the basis for the $796.03 charge to which Epstein ultimately pled in June of 2008? I did not at the time. I've read various accounts of that, but that's based on matters that I've read and not an independent recollection. Now, before we move forward, that's 796.03 is a charge. That's not an actual dollar value. That's obviously it is some sort of federal charge. So, in moving forward, and not an independent recollection in which you're understanding. My understanding is that there is at least some issue in the media over whether the right or the best victims were chosen from the prosecution's perspective. And do you know, was there any indication of who the victims were? Do you know who the victims were who were the subject of the state charges? Which particular names? No, I don't. No, I don't. Right? I'm not asking you. Yeah. Other than names, yeah. I just want to know if you know who they are or how many they were. I do not. Right. It could be one, right? For the solicitation, it could be one conceivably. Both the charges could relate to one victim, right? So those matters were very much part of the negotiation that Redacted and to some extent Andy were involved in. I did not. So this doesn't seem like it's straight up testimony. They're using terms. They have some knowledge of this case. They're saying people like Andy, who is Andy. So this is obviously an inside conversation about how this case is going. And to some extent, Andy were involved in. I did not. What makes you think that your people were negotiating which victims would form the basis? Fair point. Okay, fair point. I withdraw. They may not have. I don't know. I don't know how in the weeds and how much our folks as a federal system sort of interacted with the state in terms of what punishment. There's at least some discussion in the media regarding whether the punishment was a function of the victims and registration, and I can't speak to that. All right. Are you aware, just as a point of interest, that the public record of the proceedings in the state court related to Epstein are utterly silent as to who or how many victims form the basis of the charges to which he pled? I know. I was not aware. Okay, so this idea of many victims coming forth in state court and so on is not really in play. All right. Do you have a 2-year, 2 years has been now, a 2-year state deal has been announced to the team by Redacted. So Jeffrey's already working on getting a deal, and clearly just from the tone of this conversation, the person asking these questions is trying to get that deal fulfilled for 2 years. Now, we know before that there was a lot of scrutiny for Epstein getting that sweetheart deal with the AUSA we mentioned earlier, a couple episodes back, and this is probably how that came to fruition. So we're going to continue. Yeah. With your knowledge and approval, right? Because he wouldn't do it otherwise. Is that right? Fair. Though at least one was surprised. Do you know what drove the timing of the plea offer? In other words, why did it have to be made at that point? I do not know. I do not. Okay, you know that Redacted submitted his resignation on the 23rd of July. I saw that in the right, in the documents. In the documents, he submitted that to you, among other, as well as the, HR people. Why not? Well, then there was a July 31st meeting at which the term sheet was presented. This document 15 is the term sheet that was presented, as Redacted indicates in her September 6th cover email, and you said you approved it. You happen to be copied, right? So let me forward this. But now, I'm reading all of this. Seems to be a lot of direct quote, but like I said, for transparency, every last one of these documents has to be read, so we will continue. Let me be, even if it doesn't sound like a normal conversation, which it does if you were reading it literally. But let me be accurate. I approve these terms, whether it was this specific term sheet or another document that might have been earlier that looked highly similar to this. My recollection is approving a resolution that had him pleading to certain state counts, that had a binding 2-year plus recommendation, that provided for 22.55 restitution. So basically, they want to make sure you get some jail time. They want to make sure the victims get some money. Right, but you don't know if it was this sheet of paper. I can't say 12 years after the fact whether it was this specific sheet, right, or all right, or others. Based on the fact that this was in the email, I think it's safe to assume. But to assume what? To assume that it was this? Oh, but it's possible that there was a slight, I'm assuming this is supposed to say a slight difference. And all right, in fact, this same document with a couple of, additional bullets that had to do with the date of entry of the plea, sort of ministerial, is what was prepared by Redacted on or about the 31st, on or before the 31st of July, and this document is indicated. Here, along with the attached guidelines, calculations of what was provided to the folks who met on the 31st. Fair. Of July. Okay, so on that 31st, it was Redacted. Jerry left court. Redacted. Sanchez. And the purpose of the meeting was Sloman, Minshall, Lori, and Redacted, as well as the case agents, was to present the plea offer. And did you get briefed on how that plea offer went? I don't recall being briefed, but in the regular course, I would have been. All right, and at that meeting, there was an expression of concern by the defense team that Epstein wanted to avoid being incarcerated in the state system because of concerns for his physical safety, and that concern was accommodated to the extent that the U.S. Attorney's Office term agreed to explore federal resolution. Okay, so that explains why they were talking about the state versus the federal charges. It appears that Epstein's lawyers are trying to give the prosecutors what they want, which was a win, but the defense is also trying to get what they want, which is minimal punishment. So despite all of the horrific actions of Jeffrey Epstein, here he is being concerned about his own safety if he were to go to a state prison. How does that square with your decision that a state plea is how this case was going to be, right? So it seems like the state is they want to go with state charges. They don't want to go with federal charges. Decided. So I think I indicated later that it's a little bit more fluid than a decision here or a decision, than binary situations. My recollection is we were very focused on this man should go to jail and this man should register. The 2-year plea to the state charges seemed reasonable and seemed a way to go. We can agree or disagree. Reasonable in terms of, not in terms of, was it the most just outcome, but seems like a disposition that we would agree to. But ultimately, the focus was on getting him to jail, and if that meant exploring at 371, it's at least worth exploring. And so I don't think it was inconsistent, because the focus really was on he needs to go to jail. Okay, in this case, that pushback of that resulted, right, in the agreement to explore a federal plea. Right, so he wants a federal plea. I'm assuming he thinks that federal prisons are more secure than state. Because, state charges, they can have their ups and their downs. Problem is that you're in the state. But as far as federal charges go, it's my understanding they do more time, but it's more regulated. But as far as the state, probably does less time, less regulated, meaning it's probably a lot more dangerous for him to go to a state prison as opposed to a federal. So it says in the agreement they're exploring a federal plea. They want him to plead guilty. In most cases, they want to win. So if they can get the person they're trying to lock in prison to admit to being guilty, they'll throw them a few bones, and then it looks like these are the options that Jeffrey and his attorneys are exploring at this point in time. Because as I said, through this entire investigation, that the evidence is overwhelmingly damning was because Epstein was afraid to be in prison. Why would the U.S. Attorney's Office accommodate that? Now, this is the question that all of America's been asking. And here we're beginning to talk about a major point of criticism of this whole process and the outcome, and that is that it appears that the U.S. Attorney's Office was bending over backwards to accommodate the concerns of Jeffrey Epstein. Now, this was brought into the forefront around this time period because that's exactly what it looked like. And this individual, who I'm assuming is part of the prosecution, is wondering the exact same thing. And in this case, or maybe he's a case manager, and in this case, he was uncomfortable going to federal or state prison, but all child predators who go to prison are going to face some, challenges, right? Right, and I remember along the way a heavy push that he be incarcerated at this home under some kind of home confinement. And my reaction to that was, no way. Right. And okay, you don't like prison, but that doesn't mean you get to be incarcerated in your house. Which is interesting because subsequently, because subsequently what? You might as well finish. Well, because that subsequently the way that the state executed the terms of incarceration were not what I would have expected. And so again, the focus from my perspective is he needs to go to jail. If the team agreed to explore it, the 371 was on the table to the extent we had been. I'm speculating now. This is not to make the record clear. Thank you. I'm speculating, not recalling. I can speculate a 371 with a 2-year Rule 11 had been discussed based on the contemporaneous record. And so to the extent it had already been discussed, even if it was not in the direction we were taking, would it have been unusual for folks in the room to say, well, look, we've discussed that, let's go back. Let's see where it goes. I can't fault to the extent it had been discussed. I can't fault anyone for saying, let's go back and look at it. I think that's distinguishable, at least, from subsequent. All right, at that point, the defense was given 2 weeks to take it or leave it, and if not, you would indict, and there were several occasions, correct. When that kind of ultimately was made, did that mean, given all of your concerns about barriers to what you would consider a successful federal prosecution, was that a bluff? No, it was not. It was not. You were at some level at least prepared to approve the presentation of the presentment of an indictment. We should not have gone forward with these negotiations if we weren't ready to. All right, to approve. Whether in this form or a different form and an indictment, and I say that because it was very much a draft indictment that hadn't been reviewed fully by the chain, but it wasn't a bluff. Well, by this time it had been reviewed, and it been reviewed and revised, and it had there had some efforts to begin revising. So I'm reading this, direct quotes. It may seem as if I'm stuttering here, but no, this is basically two guys talking over each other, and one's wondering why he's getting a cushy deal, and the other one is basically admitting to everything. Yes, we are trying to work out a plea agreement. Yes, a 2-year offer was on the table, and Jeffrey Epstein is trying to get out of registering and going to prison altogether. But you know what? He was a billionaire, so can we be shocked that he would even attempt to do something like this? Of course not, because we should be shocked by his actions. He obviously thought he was above the law and had no consequences to any of his actions, which is why he just blatantly, just openly was doing this stuff. You saw when they did the surveillance, there were random young girls walking up to his house throughout the day. It was in broad daylight, literally and figuratively. There was no checks and balances. So we're going to continue what appears to be a jumbled conversation, but it still makes sense when you put it all together. So yeah, it wasn't finalized. Yeah, some efforts to begin. Exactly. Right, okay, looking at 11A, this is a letter that Redacted drafted to sort of actually respond to a counteroffer by the defense. The counteroffer is presented in Exhibit 10B. Now, this isn't even the defense's offer. This is the prosecution. But not to get off topic, which is a letter from Redacted Sanchez, which we don't need to go into any detail, because as you've already pointed out, essentially it was a home confinement, very, very soft. Yeah. Landing counteroffer. And 11A Redacted tweaks Redacted letter. You're copied on this, and the date is August 2nd, Thursday, and he notes that he hasn't discussed it in detail with you, but he wanted to. He hoped that tomorrow, Friday the 3rd, right, he'd have a chance to. And what's notable here is that there's strong language that the office believes that the federal interest would not be vindicated in the absence of a 2-year term of state imprisonment for Mr. Epstein. That offer was not meant as a starting point for negotiation. It is the minimum term of imprisonment that will obviate the need for federal prosecutions. You're on paragraph 2.1. Okay, so it looks like perhaps they're reading over the proposed plea deal, which is coming from the prosecutions, which is, I find crazy, because they shouldn't have offered him anything. He should have went to prison. As far as his safety, him wanting to go to a federal prison as opposed to a state prison, they should have sent him to a state prison. They should have not given him a 2-year plea deal. There shouldn't have been any home arrest or house arrest even on the table. But here we are, looking at these two parties negotiating a sweetheart deal, as we like to call it, for Jeffrey Epstein. So we're going to move to the next page. We're about 40% through this episode. This is going to be a long one because there's a lot of Q&A sessions here. But it is short dialogue. So will this end up being a 2.5-hour episode? I'm not sure, but we're going to continue nonetheless. 1, yes, 2. Yeah, it's the first, right. Long paragraph, and then he also states that, you in the last paragraph, the U.S. Attorney Acosta has asked me to communicate that the 2-year term of incarceration is non-negotiable. So this leads to what ended up being one of the most controversial aspects of the entire Epstein case. So Acosta was accused of giving a sweetheart deal, and it's clearly indicated now, after all of these pages we just read, who we've been discussing and who was a part of this conversation. And this is Acosta, Attorney Acosta, who was known, like I said, for giving a sweetheart deal. So they want to know what they can get out of, and basically Acosta's saying, look, he has to at least do 2 years in prison. It's a non-negotiable thing. And now the defense is trying to whittle that down. Yes, that's pretty firm. That's a line. It is. And the concrete that is setting, right? Right. And 11B is the letter as it actually went out the next day, and it's got the same language. It's identical. It has the same language. It has one typo corrected. This is redacted last day in the office. Yes, and he's gone after that. Do you think that this was an appropriate timing to extend this offer, or to set this as the minimum offer? Or was it something that you would have liked to have seen more fully developed in negotiations with defense counsel? I'm sorry, I don't understand your question when you say more fully developed. Well, you have 2 years. Would further consideration have led the U.S. Attorney's Office to decide that, well, maybe the 2 years is too much of a giveaway, we should stick with a 5-year federal plea? Yeah, I can't say, so I can't speculate this far after the fact whether waiting an additional time period and further discussion would have changed things. I could tell you how we came up with it, but that's a lot of speculation. Would you say that redacted was, as the criminal chief was essentially the driver of the resolution? Right. Presented in this letter, I can't. Again, you're asking me to speak to something from 12 years ago. I can't speak to it. I was aware of the multiple prongs. I approved it. If we had, at some point, is your question, is if at some point there had been a let's sit down and reconsider meeting, would you have gone in a different direction? Perhaps, but I can't, 12 years after the fact, speculate as to what may have happened if something had happened. All right, that's just a lot of hypotheticals. Understood. The question, though, was whether Matt Minchell, who was the author, right, of this, who first raised it, right, with redacted Sanchez, yeah, in an informal discussion, who presented it to the U.S. Attorney's Office team, was this really his baby? I can't. Approved by you. I can't. I don't remember who I talked to about what, and so it wouldn't be fair for me to, I can't single out any person as having a greater or lesser role. So basically they want accountability here, and of course Acosta is brushing out just as well. Well, not as well, but same fashion that Ghislaine Maxwell did, which ended up leading to her being charged with perjury. But just to be fair, Acosta did receive a fair amount of scrutiny when he gave Jeffrey Epstein a sweetheart deal for these heinous acts. Well, you are not the architect of this, right? You approved it as you've described it. No, I haven't said I wasn't the architect. What I said is I don't recall. And what he means by I don't recall is basically he's trying to avoid responsibility for giving the sweetheart deal. So now he's just going to have amnesia when it comes to remembering any of the particulars about the case. So I'm going to repeat that last question. No, I haven't said I wasn't the architect. What I said is I don't recall. Right. I recall approving it. I think what I'm trying to convey is these discussions are much more fluid than I think any one single architect. That's what they wrote. You've got multiple lawyers. They interact on a daily basis. They talk back and forth. To sort of put it in an OPR context, there's probably not going to be a single author to the report. They're all going to go back and forth, and there might be someone that maybe there's a single author. Who knows? But I think it's difficult to say there's a single person. And ultimately, I was U.S. Attorney, and so I approved it. So this is Acosta's words in the non-bold, and the person questioning how we came to this point where he even got offered 2 years. Not even from the defense, because that sounds like something the defense would have came up, hey, how about 2 years? But in Epstein's mind, he wanted 0 years. So, and even what the what the prosecution proposed for Epstein was far too lenient. And now Acosta's trying to explain himself as to why he even offered it in the first place. To your knowledge, did anyone in that chain of that 5-person chain or anyone else disagree with this offer? 2, I'm not talking about. To my knowledge, I think redacted at sometimes may have felt uncomfortable, but whether there was explicit disagreement or not, I don't recall. In terms of my management chain, I don't recall any disagreement that you were aware of, that I was aware of. I recall discussions, so for example, redacted might say I might proceed with 371 with a 2-year cap under Rule 11, but then we move in this other direction, and I don't recall anyone saying, let's take a timeout, let's reconsider. And let me just clarify. I think at various points in this case, and it's hard to sort of single out the timeline, Miss Redacted was supportive, or maybe I wish we would go in a different direction that sort of went in and out a little bit. Mind you, this is Acosta. On her part, yes. So now he's blaming. Let me ask you this. Having reached the decision that you approved, right, that this was the offer in the term sheet, or the terms having that decision made, would you have expected your line AUSA to frustrate that or to not abide by that since it was your decision? Note with a caveat that if at any point someone felt truly uncomfortable, I would expect them to come and talk to me about it. Can you recall any instance in which line AUSA came to talk to you about a disposition that he or she was uncomfortable with? Yes. So I'll give you an example. I don't recall who before you asked me, but there was this AUSA who was new to the office who impressed the hell out of me. I'm sorry, that's not appropriate language. Who impressed me significantly. He had inherited a case, and it was a fraud case, and the big players had been charged, and he was basically given a lesser player to basically just finish up on, right? It was a done deal. The person was ready to plead to some minor count, no jail time, and he felt uncomfortable with it and went to his supervisor and then ultimately came up to me, and I had a discussion with this person about it, and it ended up with my telling him to go back, call the defense counsel, and tell them we were dropping the case. Which for a new USA in the office is pretty gusty and unusual. But if this person really felt that this lesser player wasn't deserving, then that was the right thing to do. Right. So and the person was not punished for it. If anything. You know, I recounted that story to others. Okay, a question shifting gears. Yeah. A little bit about 18 U.S.C. 2255. Yes, okay. Not to be confused with 28 U.S.C. 2255, which every prosecutor is familiar with. So whose idea was that? It's a civil provision, it's not restitution, it's damages recovery provisions in the criminal code. Right. Who came up with that? I can't speak to who came up with it, okay? Can't speak to the reasoning behind it. Your reasoning or the proponent's reasoning? My recollection of the reasoning as to why we thought it was important. The importance was to provide a mechanism for recovery of damages. Okay. Yeah, I mean the victim's bad situation and here is, well, go on. All right. Might circle back on something. So is it fair to say that's had you ever heard of it before? Had you come across it before? I don't know, but I don't think so. Okay, so is it fair to say it was novel to the office, to you and to this team? I don't think it's fair to say that it's novel to the office. Well, do you recall whether anybody in the team had experience with 18 U.S.C. 2255 in a criminal? I don't have a recollection of any discussion as to whether people had experience with this or not. Did you believe that any legal research was needed or should be undertaken to ensure that the procedure was in fact legally sound when embedded, as it was in this case in a criminal plea? So I would have expected, to the extent that there were concerns, again, we had incredibly experienced between the various individuals on my management team. We probably had 50 years plus of criminal experience. I would have expected, to the extent that there are concerns, for those concerns to be raised. Did you raise any such concerns about it, or did it seem to make sense to you? From my perspective, I recall, I don't know if it was at the time or subsequent to it, reading it, and it seemed to make sense. Okay. After Redacted's letter went out on the 3rd of August, you almost immediately, it appears, you received a telephone call from Kirkland and Ellis. Is that correct? That I don't recall it independently, but that's what the record shows. All right, and that's reflected in Exhibit 12. Do you remember who called you? I do not. Do you recall it apparently was from the context of this Exhibit 12? It in the caption Epstein. Right. It appears that the call related to Epstein, correct? Correct. Again, I don't remember the phone call, but from the email I accept that it happened. So, well, the reason he's accepting that is because it's an email. You can't refute an email. You can refute the context of a phone conversation, but an email is an email. So he can't deny the fact that he received an email being questioned about this. So, what had been your knowledge and relationship with Ken Starr of Kirkland and Ellis? Right, up to this point. So I had been an associate at Kirkland. I think I indicated what was it. So he has a relationship with the people we're speaking in this case from the past. That's always a conflict of interest. I digress. From 94 to 90, what was it? Was it 96 or 97? Couple of years. For a couple of years, I worked on at least one case that I recall with him. I was the junior associate on a merits brief that he argued. He at the time was also special counsel, and so he wasn't in the office nearly as much because he was double hatting as a special counsel. And partner. All right, what was about Redacted? So Redacted was a partner at the time. I don't recall working with him on any particular case, although I think I worked with him on at least a matter. He was on my hallway. He had an outside office. I had the typical inside office. Had you had any interaction, any contact with them in their intervening years, socially or professionally? Off and on, I was in Washington. Ken Starr was in Washington. I think Redacted had moved to New York, but then came back to Washington to be in the administration. And he was in the policy office, and we we likely interacted. And while you were here at the Civil Rights Division, correct? All right, and were you friends? Were you professional acquaintances? Were you what? How would you characterize that? We were professional acquaintances that had worked together several years ago that continued to interact. Is that true as to the two of them? I mean, it's hard to characterize these things. I think that's fair to say. Did Ken Starr know who you were? Yes. And obviously Redacted as well. Yes. Okay. So what was your reaction to being contacted by them, by their firm, then presumably one of, right, then perhaps. So I don't know who called based on the email. I can't interfere that it was one of them. So he's just lying left and right here. And it's an admission of guilt. Well, he just can't remember anything. He doesn't remember phone calls. He doesn't remember people bringing concerns to him about him giving out this sweetheart deal. He just doesn't remember. And I think my reaction is captured by not my email, but by Jeff's comment. And what I don't have a clear recollection, but I'm going to speculate, interfere that I heard they were being brought onto the case. And I probably walked down to Jeff's office and said, hey, Kirkland, coming onto the case. I bet you they're going to come on too and try to take this up to DC. And then I got a phone call. And then I tell Matt, who tells Jeff, I didn't know, maybe Kirkland made a call too. You're right. Unbelievable. Then I say they're likely to go to DC. We should strategize a bit. My concerns behind that are, will DC look at this as sort of legally troubled? Going back to the earlier points that I made about the policy issues around the trafficking issues up here in DC. And I really do think he should go to jail, and so I want to strategize a bit. So did you have concern about the fact that the defense team was sort of appealing you to the big house? I think based on this, I almost predicted this would happen. Yeah. And Jeff is saying you were right, unbelievable, where I, in some way, shape, or form, predicted that someone would be hired or something would happen to take this all up to DC. So, at this point, there's no mitigating this. They can't make it go away with a plea deal. This was big news. As we saw, there were Netflix specials made about it. The victims came forward. So, this is an unavoidable case that was going to be in the public eye no matter what, even though they did their best to basically make it go away. And had you experienced other cases, other instances which defense team went to DC while you were at U.S. Attorney's office, while you were the U.S. Attorney? Yes. Was that a concern to you? It wasn't a concern. It was how do we address this so that we can back our position in our office? Did you have concerns about the disposition that was underway about Main Justice scrutiny of the MPA scheme? So I had no concerns about Main Justice scrutiny of the MPA scheme. In fact, I invited Drew to come down. Right. And he was part of the meeting where we discussed the MPA, and so I say that because if I had concerns, I wouldn't have invited him. If anything, my concern was, is Main Justice on board, or are we going to basically be told to drop this case when it goes up to Main Justice? In your email to Redacted, when Sloman's on vacation, yeah, you say that you make reference to a process file, that the attorneys and the defense team want to go to D.C. on the case on the grounds of a process file. For example, that I have not met with them, and you expressed concern that would delay matters. Is that what led you to agree to meet with the defense team on the 7th of September? It is. My concern was they came up to D.C. and the first talking about was the U.S. attorney didn't even agree to meet with us. That's not the best. That's not the best foot to start when you're having your case reviewed. So what was your understanding of what the purpose of the meeting on September 7th was supposed to be? They wanted to argue, they being defense counsel wanted to argue why we should not pursue this case. And in this case, it was Starr and Lefkowitz from Kirkland and Ellis and Lillian Sanchez, I believe, who met with you. Fair. I remember it was Starr and Lefkowitz. I don't know if it was Lily Ann. All right, and our information was you, Drew, Osterbahn, Sloman, Redacted, and John Macmillan. Do you know John Macmillan? Vaguely. All right, he was an AUSA as well. Right, correct. In West Palm. Right, and if I could just add again, I invited Drew. So Drew became fully aware of that, and my concern in getting Drew into the meeting was to not have them appeal us, and then having Drew say not a good case. All right, so were you aware that Drew Osterbahn had, in preparation for this, gone to West Palm and actually gone through the evidence and met with the case agent in the line AUSA? I was not. Drew is an independent actor and could do what? Yeah, what he thought appropriate. Does that seem like an appropriate thing for him to have done in your eyes? Sure. Okay, would you describe the meeting? Oh, and two other people who were there were, again, ASAC Val Parlave and Junior Ortiz. Right, the SSA. So in the meeting, I think I was in West Palm Beach. Yes, so what do you recall about the meeting? The dynamics, who spoke, how did it go down? I recall there were a lot of people. I think Mr. Starr spoke most of the time. I think my recollection, as best as I can, with the caveat I thought Redacted was there and clearly he wasn't. So presented several agreements. I then either left the room with my team or I think I most likely asked them to leave the room. I then went around and asked who to leave the room. Asked the defense. I then went around the table and I said, does anyone have any concerns or something to that effect? And then hearing none, I asked them to come back and I reaffirmed the position of the office. In other words, you sort of decided, you ruled from the bench, as it were. Fair enough. Okay, you didn't take it under advisement. You gave them what your position was right then and there. That's my recollection. I don't know if you have information contrary, but at least, okay, that's my recollection. Okay, so is it fair to say it was more of a presentation on the part of Ken Starr in his side rather than a debate or discussion? I think that's fair to say. I may have asked a question or two, but my recollection was not a negotiation. But let's hear you out. And so we understand it was mainly a federalism presentation as opposed to evidence. Is that correct? I believe that's accurate, yes. And in your letter to Ken Starr, dated, the letter is actually not dated, but we know that it was sent on the 4th of December. Okay, of 2007. It's in this package. You noted that. Which exhibit? Mr. Gonzalez, 34, by Redacted. Thank you, Exhibit 34. You note on page 5. You refer to the federalism arguments, and you say that after considering the arguments and conferring with the FBI and Drew Osterbahn, you decided to proceed with the indictment, but that you would delay presentation of the indictment to allow the defense to appeal to D.C. Does that mean that you didn't find the federalism arguments sufficiently persuasive to you to change your position? Yes, with the position defined as some concern, but if we don't come to a resolution based on the sheet, then we indict. And there is a letter by Redacted. I'm sorry, when you say some concern about the federalism arguments, yeah, going back to what we talked about with respect to the earlier conversation about solicitation versus trafficking in the federal nexus. But back in July, we had decided that we were going forward, that either there is this pre-indictment resolution or we go forward with an indictment. Now, when they say pre-indictment resolution, they mean a plea deal. That just sounds better. The September meeting did not alter or shift our position. By redacted, even though you had some federalism concern of your own, they didn't rise to a sufficiently high level. So their request was to drop the matter, right? And okay, going back again, understood. There is legal risk, there is witness risk, all of these. If we can get pre-indictment resolution, good. If not, the indictment was not a bluff. It was real. So he's trying to justify, this is Acosta, giving Jeffrey the 2-year plea deal. So Ken Starr is, of course, well known, right? He was a solicitor general. He's, etc. Did you find his arguments well set forth impressive? So you're asking for something that's 12 years. If I had to characterize by the time this meeting took place, there had been a fair amount of thought around these. There had been a fair amount and I at least felt comfortable that while there was some legal risk, we needed, you've got to balance the legal risk and the present risk with outcomes. And Mr. Epstein should go to jail and should register. And I felt comfortable enough to basically reiterate our position but my question with respect to, was, did you enjoy the give and take with a man of Mr. Starr's? In all candor, no. Standing? No, not at all. Not at all, because, it would have been easier to not have the meeting in the first place. Do you recall an exchange? Were you the person to whom he was directing most of his comments? Most likely. And do you recall any exchange with him about the fact that sort of an observation that the two of you and he, were the only 2 people in the room who had been presidentially nominated and Senate confirmed to any position, so that the 2 of you had kind of that community? Does that ring? Do you mean a bell? Was he trying to butter me up? Was he? This was 12 years ago. I don't recall. I think as we talk about this, it's important to note that the position did not change. Whatever exchange there may have had, our position did not change. Right. After this meeting, within a few days, in furtherance of the resolution that had been offered, redacted, Lori met with the state's attorney office to sit down and try to work out how this thing would work. And mind you, this was well before the MPA is. Right. Actually formulated. Did you learn what happened at that meeting? Do you know how it devolved? I may have. I don't recall, sitting here today. All right. It's at this meeting that somehow the 3 charges that your office specified in the term sheet, became 1. So suddenly Epstein was to plead only to 1 charge, and this was agreed to by the U.S. Attorney's Office folks who were there. Do you know how or why that happened? I haven't the slightest idea. So Acosta is brushing out of everything, and they've even combined the multiple charges to 1 charge, basically making it seem like they were trying to get the simplest conviction humanly possible. If you had known, if they had called you on the phone, sort of mid-trial, called to the boss asking what you wanted them to do, what would you have said? So from my perspective, when I said, when I indicated I approved this term sheet, this is the minimum, I meant what I said. I also recognize that AUSAs in the usual course need some degree of discretion to negotiate. And so to my assumption, after that September meeting, I think I indicated that there was a deadline. That was fairly short. Was that redacted and some working together? Would you go back and work out an agreement based on those terms? And in the give and take, if they think that this is an important concession, that's within their discretion, but I would have been comfortable sticking to that. With charge sheet, with something that drove me is when I said something, as a general matter, I didn't bluff. I really meant what I said. So in that terms sheet, to be fair, what Minshall's letter says is 2 years. Right. Is the minimum if the decision to agree to let him plead to 1 as opposed to all 3 had no impact on that 2 years, would you have cared? Fair enough. And so going back to where to an earlier discussion, can I get another Red Bull? Wow, he needs another drink. Going back to earlier discussion, I think I indicated that the state charges, I wasn't familiar with. And so if in the give and take those charges changed, my focus was on 2 years registration and restitution, as long as those charges were captured, the conduct in some appropriate way. So basically, Coast is going for the most basic minimum they can get, as opposed to pursuing a maximum charge for these heinous crimes. It seems like the person asking Acosta these questions is putting him through the ringer to the point where he feels he needs another Red Bull. So later, rather much later, the defense counsel admitted that at this meeting they thought, yes, that under misinformation from the state attorney's office that charge that they got the U.S. attorney's office, or somehow the U.S. attorney's office approved, the 796.03 charge was not sex offender registerable. And that's a pretty major mistake, right? It is. And I mean, that goes to the heart of you and one of your major concerns. And they tried to get us to change that, and I said no. The defense tried to get you off sex offender registration pretty vigorously. Right, but at this point the focus is on the charge, and the defense is, one might characterize it as trying to pull a fast one by agreeing wholeheartedly to plead to one charge, knowing or at least believing incorrectly that it was not registerable, and the U.S. Attorney's Office not having that belief but thinking it was registerable. So there's a disconnect. There is error, and the error stems, as they later learned, from the ASA herself. So we looked at that and wonder whether that shouldn't have raised some concern that this plan to put things back in the hands of the state, which had kind of mishandled the case to begin with. I'm assuming he meant to say to begin with, as at this point, even not a good idea, because they were continuing to be, well, I won't characterize it, but less than reliable. Is that a fair comment of concern? So one question I would have is, at what point did we become aware that there had been, first, the error was in our favor, not the defense's favor, because Redacted got it right as opposed to the ASA? Correct. And secondly, at what point did our team become aware of them trying to pull a fast one? Was it before or after the signing of the MPA? It was well after. Right. But the point here is that the U.S. Attorney's Office folks were not as familiar with the state procedure, the state criminal procedure, and the ins and outs of the sentencing and incarceration, as you learned later. So didn't this put the U.S. Attorney's Office side at a substantial disadvantage in trying to play in the sandbox in which both the defense, local defense counsel, and the ASAs were really comfortable, very comfortable? Possibly, although I would point out that it was the AUSA who got it right. Eventually. Not eventually, the AUSA, was correct in her analysis, right? So in this case, she was more familiar than the state attorney. Not by practice, but by research. Or by research, and so, right. My point is, we had good people that were able to, if they weren't familiar with something, the research clearly worked. But it took, as you saw in the process of dealing with the work release and all of that, it took a lot of it. It worked to keep up with those. It did errors, which is why I say in hindsight, if given all the effort that took place after this deferred to the state was reached, if all that had been known, I really think the analysis would have proceeded differently, because that was what was a lot of work. There was probably as much work, if not more, than a trial. Right. Meanwhile, we'll talk about the actual text of the MPA in a moment. But following that, actually, no, before it was finalized, Redacted was working to identify a federal charge, as we discussed before. In that process, she came up with a plan that would have resulted cobbling things together in an 18-month sentence instead of, 24 months. Somehow that became the new floor, the new standard. Do you know how that came about and who actually agreed to that? I don't. I referenced the one email where I think Redacted says he argued 12. So he's already starting to stutter, which means he's really feeling the pressure. Right. I said 24, we agreed to 18. I assume in the give and take this was an agreement that was reached, but that was 18. As to the potential federal charges, it somehow became imported into the state deposition. I can't speak to that. This was something that the trial team was negotiating, and from my perspective, that is, these were the terms that we wanted. These were the terms that I expected if they came back and said no deal. Disappointed, but go forward. But they tried to get a deal, and the defense tried. No, but our prosecutors. And to some extent, you know, in the give and take of any negotiation, I don't think it's unfair for an AUSA to give up some things. Wow. So, yeah, Costa is in question here. Heavily. Because you see, they were just talking about getting the 24 months knocked down to 18 months, which would have been a year and a half. And this is bare bones, bare minimal consequences for heinous crimes. But you had stated clearly to not only the defense team through the Minchell letter, but also, I believe, at the end of the September 7 meeting, that 2 years was the deal. So did somebody come to you and say, look, looks like it's going to be 18 months, and allow you to then approve that? I don't recall if someone came to me separately or independently of the final language. I clearly approved it. I clearly approved it at some point. And so to the extent it was approved, that's on me. But I would argue that, you know, someone's negotiating. One side says 24, another side says 12. They say let's agree to 18. To some extent, as a U.S. attorney, I think I have to back the negotiating discretion of my AUSAs. So he just made up a term. No one probably even attempted to get 12 months, but it sounds better than, it makes 18 sound better. But you explained quite eloquently the reasoning for the 2-year plea as being what Epstein would have faced if he'd been prosecuted. Right. You know, absentia by the state appropriately, and then suddenly, without any apparent relationship to that analysis, the 18 months pops up from an effort to try to get federal charges. And so how does that not undercut the basis for the 2 years? So I can provide the reasoning for the 2 years. I also, though, think as a supervisor, as U.S. attorney, it's important to understand that when individuals go out into the field, negotiations take place. And if every time there is some give, they need to come back to the U.S. attorney, or there's fear that the U.S. attorney will not back us, you know, there's a management issue there, in that if an AUSA speaking on behalf of the U.S. makes an agreement, as long as that agreement is within a certain range, the U.S. attorney should back that, because they're the ones that are on the line. They're the ones that are managing the case, and it's not sort of unfair to consistently second guess those late night. I don't want to characterize it. So basically, he's making excuses once again, saying, oh, I wasn't really working the case, and we trust our AUSAs that if they get a deal, we should support it. Okay. It's a late night negotiation, but that give and take, that happens sometimes in a conference room or on the phone. Do you know exactly what give and take occurred in this case regarding the 18 months? I do not. I read that one document. Okay, but I do not. All right, any other questions on this one? By redacted, really quick. I agree with what you're saying in principle, but in this case, you had almost like a mandatory 2 years is the minimum. Right. U.S. attorney will accept under those circumstances where you have come out and said, this is the minimum we'll accept. Would you have expected them to come back to you to get approval for any kind of reduction in that amount? Now, that's a great question, because he's basically saying, Mr. Acosta, you said it was 2 years minimum. So how did 18 months even become part of the question if he had already set the bar? Would I have expected them? I think Miss Redacted was in a tough position because opposing counsel was coming at her. It was a tough negotiation. Would I have wanted 2 years? Yes. Would I fault her for agreeing to 18 months? I don't think that's fair to her. Well, if he's the acting U.S. attorney and he says it's 24 months, it should be 24 months. So basically what he's saying, having known what he said, that it needed to be 2 years, don't you think they would have came back for approval if they would have agreed to allow him to walk on anything less than the 2 years that he said was mandatory? Now he's brushing out, saying he's covering for his AUSA and that he's letting her do her job. You could have said no, right? I could have, but but she had agreed to it. The process had gone further down, and to some extent, I think there's a need to respect that process. That happens, I guess I was getting, this is not the only case where a supervisor sort of says, this is our standard, and at some point things move and you've got to provide some discretion. All right. By redacted, do you think she misunderstood the priorities, that she thought you wanted to get to a resolution, and so the 2 years could be undercut, versus taking your words literally and saying this is the line in the sand beyond which you should not go, even if it means kill the resolution? So if I had to speculate, I don't think it was a misunderstanding of priorities as opposed to Opposing counsel was exhausting, and if you go through the full record, it really wasn't exhausting. Opposing counsel in this case was very good at taking any slight millimeter and turning it into, oh, so you said we could do this, and in that back and forth sometimes there is a, can't we just agree in the middle? And I understand that what you're saying, but weren't they exhausting because the U.S. Attorney's Office would not say no to them? And so they always believe from the get-go, because they have a 2-year minimum, that the office is willing to then say, oh, we can go down from there, and that set the tone from then on that they could continuously chip away at you on virtually every single turn that came about. So yes, they were exhausting, but isn't that because the U.S. Attorney's Office would not tell them no? So basically, he's accusing Acosta of just closing cases, that he had set a standard, it was supposed to be 2 years, and that he may have been undermined by his own AUSAs that had blatant disregard of him saying, look, Epstein has to get at least 2 years, and then they started having a discussion on 18 months. So yes, that's a very valid question. He's kind of saying, so they don't respect what your standards are because now you're negotiating them, working on a deal that was less time than what you said had to be the bare minimum. So I would push back because after the agreement was signed, I would argue that they did not chip away. They certainly kept appealing collaterally, and we could talk about that because there were other concerns raised there. But once we had that September meeting, between that September meeting and the signing of the deferment in favor of the state, that was all negotiated by the trial team. That wasn't a come back to the U.S. attorney or come to the first assistant. That really, to my recollection, was go negotiate with the state with the line. Well, but there were a number of things that came about later on. I mean, they continually griped about the 2255, and that got modified later on. And I think later ons are different from some reason we could talk about now or later. But there was an attempt to work this out later on that was clearly there. Redacted the witness, but I think that's very different than how was the agreement negotiated, and I think that's a different sort of timeline. By redacted, so in your mind, was she prepared to walk away from the deal if need be? After it was signed? Before it was signed? Before it was signed. Before it was signed, it honestly was get a deal, or ultimately, if we have to indict, we indict, and that's what I said. And I look at it this way, after having said that, if that really was a bluff, what would I look like, right? I would look awful. And so for that reason, that was not a bluff. That was a thought through, this is what we will do, and if you don't agree to this, then we indict, and we indict. You can't make those kinds of statements and not follow through. The office loses credibility if you do. Right? But you can keep giving on certain terms, right? Let me reread that. Right, but you can keep giving on certain terms. But my point is we did not give, with the exception of that 24 to 18. We did not give. So he's saying we didn't basically have leniency. I mean, I know I said it had to be a mandatory 2 years, and they've knocked it down to 1.5 years. But aside from them going directly against my direct orders, there was nothing else. Well, you also gave up 2 charges. So this guy is just nailing Acosta because he said, okay, we had multiple charges and it has to be a minimum of 2 years. Not only were they proposing not giving 2 years, but they also were proposing knocking off the charges to begin with. Again, I'm thinking of a 2 years registration restitution, and so with the exception of that 24 to 18, we did not get. I want to go back this morning. We were talking about our tracks, and we talked about the legal track and a little bit about the evidence track. There's another aspect to the evidence track that is in play here because there was a substantial type of evidence, and the question is, to what extent were you aware of this? In October of 2005, the local police executed a search warrant at Epstein's residence, and among things they found, there were cables and cords where there had been computers, computer equipment, video surveillance cameras, and CPUs, all of that computer-based stuff. It had been removed, forgetting why necessarily. If you look at Exhibit 29, were you aware of that, by the way, that had occurred? I was aware that the state had gathered evidence, but not much more. Of course not. Beyond that. Okay, so 29 is, I'm sorry, I'm on 21. Wait a minute, this is not the one I'm looking for. 73? do you know what? Okay, this is not the exhibit I'm looking for, and the numbers are a little bit messed up. There is a email, which I may or may not be able to put my hands on, in which redacted informs you that she really wants to get her hands on computer evidence, that it's important potential evidence, and she had a plan to get it. So the question is whether you knew at the time that the investigators had identified this computer evidence as being out there, and that they believed it contained a potentially very significant evidence against Epstein computers, surveillance cameras, given his activity. Right, in his home. He's not on it. By redacted. Alright, she did not inform you. She informed someone else she informed Sloman and Minchell on July 3rd in Lowry. My apologies, you're not on this. Where she advises them that we want to give the computer equipment that was removed from Epstein's home prior to the state search warrant as soon as possible. So there was the stuff out there, and right. As of July, there was an abiding, keen interest in getting it, and the defense team was resisting the prosecutor's efforts to get it. Were you aware of that at all? So I think you asked about that in your questions to me. Right, I did. I have no recollection of this computer evidence. So he's flat out lying. He's flat out lying. I mean, we saw how much computer evidence there was, so either he didn't read the case at all, or he's brushing out. All right. Did the question say that without getting into specifics that there was a grand jury issue around this? It does. I don't have that. It is addressed to the non-prosecution. It is addressed in the non-prosecution agreement. If you look at the final non-pros. Yeah, I don't have to. It's been referred to. The question that you asked, the question was whether you were aware that was something that the prosecutors wanted to get. A lot of double words. I don't have a recollection of some computer evidence. All right. But I think, are you? What was the question? Aware. So Acosta's trying to forget that he even has to answer these questions. He's all tripped up. Aware that Redacted was instructed by our managers to delay her efforts to get this computer evidence because the defense were resisting those efforts, and it became an issue that was in play in the negotiation. I have no recollection of that. Okay. If you can give me 1 second, sure. Pending federal, and so your question says that there was litigation pending in federal court relating to the U.S. Attorney's effort to obtain, computer evidence, without going into further detail. I had no recollection of any litigation pending in federal court regarding that. All right. And did anyone suggest to you and your team that getting to a plea deal was premature because you needed to get this evidence first so that you know whether you had potentially some very important evidence against Epstein? I have no recollection of anything. So, when in doubt, if they're going to trip themselves up in a lie, they just get amnesia. I think there was a desire to move quickly as opposed to slowly. On the plea, yes. And do you know where that energy came from? Who was I wanting to? Move quickly. As I recall, for example, when we were setting up the meeting in September, there was a request to set it up in August as opposed to September, and we had to push it back to September because of vacations or something. All right, so in addition to not getting computer evidence, the government curtailed the investigation to a large extent. Despite finding more victims, there were victims who were not interviewed, things that were not researched, property that wasn't searched, target letters not served. So these all would have been steps taken by the FBI to enhance the federal investigation, right? As opposed to back to the state, right? Case that this was sort of, being returned to, right? Mr. Todd, are you asking Alex if he's aware of all the things you just said? By redacted, were you aware of all of those steps that were being foregone or foreclosed? No, my assumption would have been we may have to go to trial, and so we should continue to develop the basis for trial. So if I could, for example, I think after Drew came down, I said, if we go to trial, can you be on the trial team? I said that because I'm thinking we may have to go to trial, right? Why not get Drew, who's from Miami, on the trial team? So is it your understanding that the federal investigation Notwithstanding the drafting, this MPA was still continuing. Yes. My understanding is you run these on parallel tracks. And again, I'm sitting here inviting the head of CEOs to be part of the trial team and talking about how to formulate the trial team. Okay. That implies that I was clearly thinking we might be going to trial. All right. When you first received the draft of the non-pros agreement, and this is 16A, it's a draft by Redacted. Do you know who came up with it sounds like you didn't, but who came up with the name of the moniker non-prosecution agreement? I do not. Do you know that what this was modeled on, if anything? Where I'm assuming that's supposed to say, where is it? What the genesis was? I do not. I noticed from the contemporaneous emails that initially it had done differently. It was done differently. I think it was Redacted Lowry who said write it as a contract, or I think there's an email to that effect. Someone may recall it better than I. But this version is September 10, which is the first business day after that. Yeah, September 7th meeting from Redacted goes to her management up through you, and you do a rewrite almost right away, adding original state charges, which at that point were all still in play. You also added this as Exhibit 16B, a statement that it would be Epstein's job to move the state to add additional charges, and that letter piece is on page 3, just below paragraph 8. So you were, can I back up a second? Sure. When you say I did a rewrite, is there some indication of what I did a rewrite of? Yes, if you compare the two, right. There are things that are barricaded in yellow in Exhibit 16B, which represents, right, the changes from 16A, right. Okay, so those are the two things that are different, and they're referenced in your message. Yeah, at the beginning, we bracketed them just to make it easier for you to recognize. Right. I don't know about you guys, but I am thoroughly enjoying this. I don't know who this individual is that's asking these questions, but he is ripping Acosta apart. But not to get sidetracked, let's just get back into it. So my point is that right from the beginning, you were participating in the process, in the drafting process. And Acosta is just stuttering left and right. Oh, so I would characterize that as not participating in the drafting process, but approving a draft. There is I did a small difference rewrite. Yeah. And so something comes, here's how I would distinguish someone that's participating in the drafting process is sitting at the table with 2 or 3 people drafting it as they go, versus something goes through the management chain and someone in the supervisory chain says, can you change A, B, or C? All right. I clearly, here in other places, it looks like I'm inserting the same themes, which is deferring to the state. Let's mention the state charges. And we can force the state to do anything. And so I'm adding to this. I'm clearly aware of it and approving it, but I wouldn't say that I was drafting it. I was drafting. Now that doesn't make any sense, because he's basically denying any accountability for the leniency that was given because he didn't draft it, even though he ultimately had to approve it. So he continues, fair enough, did you read it? I would assume that I read it. So when he says he assumes he would have read it, that means he didn't read it. Or else I wouldn't have edited it. Alright, so we have a draft from Redacted, a working draft on September 10th, with a small rewrite from you. There is in the Exhibit 17 series indication that of the kind of activity that Redacted was going through to come up with a federal plea, but eventually she and the defense attorney who was more actively working on this, Jay Lefkowitz, so he's basically saying the defense attorneys were working way harder than the prosecutors. Turn back to the MPA, and if you look at 17D, just to make the sort of staffing clear, of course Redacted is left. Redacted is going on vacation as of September 15th, and so Redacted Lori has helped finalize. So the finalizing of the MPA and the final version of which is in Exhibit 22 falls to Redacted with Redacted, right? Yes. Okay, and Redacted puts you on notice in 18B in that process. This email in 18B is sort of a follow-on to 18A. Do you see it comes 1 minute after your email in 18A? It's a response from her to you, only in which she makes notes that the defense tried to reopen all the loopholes that I had sewn shut. Yes. So it's fair to say that you're on notice that they're being difficult. Aye, that's fair. So he's stuttering again. Okay. In the course of that being difficult, 19A is an email to you from Redacted on September 18th, in which she represents that or explains that the defense is that things are kind of falling apart with the negotiations, and she fears the deal is going to fall apart completely. Mr. Todd, should we take a quick break here? You're losing your voice. I'm fine. Redacted, I'm fine. Mr. Todd, you could probably use a minute. Redacted, all right, we'll take a break. The witness, all right. Redacted, a 4-minute break. Mr. Todd, 4 minutes. That's okay. Off the record by Redacted. Back on the record, looking at Exhibit 19C, you say you write to Redacted regarding whether you're available to, at a time when she's going to be hashing out language. You advise her that, but I don't think I should be part of negotiations. I'd rather leave that to you if that's okay. Yes. Why did you say that to her? Because she was the line lawyer involved, and I think it's important for a U.S. attorney to, absent truly exceptional circumstances, to not get involved in sort of the negotiations. You could meet, like I did in September, reaffirm the position of the office, back your AUSA, but ultimately I think your trial lawyer needs discretion to do their job. At this point, of course, we know Redacted is on vacation, right? And you were aware, were you not, that Redacted lawyer was about to decamp from Washington? In other words, he left at the end of September, yes, to become the Chief of Staff and Principal Deputy Assistant Attorney General. Correct. For Redacted, yes. Who headed the criminal division. Okay, so it was really just the two of them at this point, and with nobody apparently involved between them and you. So fair. But when you say just the two of them, Redacted is an incredibly experienced lawyer. So to say just the two of them is should not imply that there was an experience in that. I'm assuming this is supposed to say inexperience in that. I certainly in no way intended to fair suggest that. Fair enough. Looking at 19D, in which Redacted is on page 2, looking at the latest draft from Redacted, meaning Redacted, and this is in the throes of negotiating the MPA. Redacted is essentially telling you he agrees with Redacted's observations that the defense are just up to all kinds of nonsense in this deal and constantly changing their terms and just not apparently negotiating or dealing with these warring drafts with the drafting process in good faith. Again, that's my characterization, but Redacted says to you in this email, I suggest we simply tell him, Redacted, that his counteroffer is rejected and that we intend to move forward with our case. Right? And then your response is interesting. You say to him, why don't we just call him? Tell him, 1, you agree, and then change things. 2, you being Redacted agrees and changes things? Correct. Tell him you agree, meaning Redacted agrees. No. I see. Yeah. Tell him. Tell him you Redacted agree and you change things. I see. That is not acceptable to us and is in bad faith. Stop it or we'll just indict and then try to work it out. So is the try to work it out if numbers 1 and 2 are what you should tell, what Redacted should tell Redacted is a number 3 is number 3 something Redacted should tell Redacted or what you're telling Redacted? Try to work it out. It's what I'm telling. Okay. So just to be clear, you say tell him meaning Redacted, tell J number 1. So in number 2, but number 3 is then what you're instructing Redacted to do. Yes. I'm just trying to understand. Yes. So okay. So my understanding of this, they're being difficult. Hey, this isn't the first time that an attorney agrees to something and then goes back and tries to pull a fast one. So tell him you're onto this, that they need to stop it or will indict, but then that will try to, Redact should try to work it out. Okay, but they need to stop this tactic. Did you really think that was going to be effective with this defense? I don't know. Team? I think one of the hardest things with this is if it was right on September 6th, it remained right. Irrespective of really, I think I say, sorry, I know it's a pain. You do. This negotiation was a pain, but if it was the right position. The fact that you've got annoying counsel on the other side doesn't make it less or of a right position. You tell them, stop being annoying, you try to figure it out, and if not, then you indict. All right, and is that sort of, you had a question? I was redacted, I was going to, but redacted was going ahead by redacted. Is that consistent with your sort of way of doing business, being even and working it out? Yeah, this is our position. It's not a bluff. It's what we want. You work it out. People yell and scream on the other side. You work it out. If not, then we indict. What would have been the tipping point for you? What would have caused you to say, okay, I agree with redacted. I agree with you, redacted. Let's indict. So it's really difficult to speculate, but I think the tipping point would have been a failure to reach. It was pretty clear. Jail time, registration, restitution. Okay, we moved from 24 to 18 months. That was a give and take, but ultimately, if they came back and said we can't agree to these terms, then we indict. All right, by redacted, it seems like your troops were telling you we've reached the end of our rope. We really want to just go forward and indict. Right. And you were coming back with, tell them again what the defense is being, tell them again that the defense is being difficult. Well, I want you to work it out. Does that tell your troops basically that where your priority is, you want them to get this resolution? And if they have to give up stuff, it's okay. It's really okay, but you want this resolution. So it's not if you have to give up stuff. I'm not telling them to give up stuff. I'm telling them to negotiate things away, but I think the dynamic from my perspective is incredibly, so there's a tactic that counsel sometimes take where they negotiate and then they try to come back and renegotiate. And that is, to my thinking, one of the most annoying tactics that you can have. And it creatures a lot of frustration. And what I'm trying to say is, look, they might be frustrating folks, but if this has been worked out, so looking at this, we thought we had an agreement. And then they change things, and I'm saying, look, if you thought you had an agreement, tell them you had an agreement. Don't let them change things. I understand it's frustrating to you, but if it was right 2 weeks ago, the fact that they are frustrating attorneys doesn't change the underlying legal analysis. The attorney's behavior doesn't inform the righteous of wrongness of a certain disposition to a point by redacted. So I think now I'm calling it an NPA. I was personally very frustrated with the failure to report on October 20th, and I had envisioned that entire collateral attack. I think I would have looked at this very differently. In what respect? To the extent that this was going back, for example, the public corruption prosecutions that we had, one of the values of it was to have a public figure stand up and say, I did this and plead. One of the values was avoiding a long and messy legal process. And so when you put all of that together, this is why I say it's not quite, this was the factor that we'd consider, that it's all of this put together. And it's something that could have been very positive for the victims, and for sending a signal as it dragged on became exhausting and negative for the victims. It put us in a position of what we do with notifications. It put us in the position of a lot of appeals to Washington. It put us in the position of having to deal with complicated legal issues that actually get more messy in terms of how does a federal 2255 relate to a state charge. And had all of that been known, I do think this would have proceeded differently. So if I had factored all of that, like I can't predict it's right, what I would have done, but I think if I had done all that, this could have proceeded very differently. I was very frustrated with the October to June time period. If you had been back in that time period in early September, looking at this with, I don't know what Harry Potter character it is, right? But whoever could see in the future and anticipated or foresaw, right, what would have happened? Would you have simply said, look, we're not going to go to the state route, we'll go the federal route? Quite possibly. All right. And let me we'll probably get into it, but at some point, I do think the post versus the pre-signature time period was different for any number of seasons, and we'll probably want to talk about that. All right, we will, but now I'd like to turn some of the terms of the fair. The MPA, because you did let me make sure that this is correct. You skipped this one by redacted. Oh yeah, before that, thank you. My colleague reminds me 19E is an exhibit that has a dash in exchange between you and redacted Lori about at a time when the plea agreement, the federal plea agreement, right, was still in play, and the issue is whether you should sign it. And right, you didn't want to because you never do, but you say at the bottom we should only go forward if the trial team supports and signs this agreement. What did you mean by that? The first of it. So what I mean by that was I got something that the document was unusual. So my signature appearing on this document is not in and of itself unusual, and this would have been the plea agreement, not the federal plea agreement, not the dash, or was this about the MPA? This is about the MPA. Okay. Right, and so the MPA had my signature. Now the MPA is almost too generous. So that in and of itself is not indicative of amazing, but it does raise my concern. Is this something that ultimately the trial team does not feel comfortable with? If it's something they don't feel comfortable with, then they should speak up and let me know, because we shouldn't go forward with it. And did you ever have a conversation or a discussion about that issue other than mentioning it? Not to my recollection. I would. Okay. Assume back on this that redacted would read it and would take me at my word and say, look, if I think you're going in the wrong direction, Alex, I think you're going in the wrong direction, or I'm uncomfortable with it. Okay, all right. By redacted, did you ever have a direct conversation with redacted about wanting her to sign the agreement as opposed to herself? I did not. This was my communication with redacted, and I really meant that if at the end of the day my team isn't comfortable, then you shouldn't go forward. The never recall hearing from redacted that she was not comfortable moving forward with the plea agreement by redacted. The MPA I did not hear. I don't recall hearing from that she was not comfortable. I know that at various points she became frustrated. At various points redacted became frustrated, but they were negotiating this. If at some point they did not, they thought this was a mistake, wrong, or unjust, I would think that they would tell me. What would you have done? Sit down and really have a serious conversation about where this is going, and sit down and hear them out again, even if dash at this late phase. Right. I would think that that's what I should have done. All right, let's turn to the MPA. What is it? Exhibit 22. Did you read it? We know that you made some final tweaks to it. 22. So is the final as signed? And so I don't have an independent recollection of reading it. I would not have made tweaks to it without reading it. Okay. And so I think you can infer that I read it. All right. And let me say you were clerk to a very eminent appellate judge, and did you do appellate work? I did. Yourself. So you were somebody who's an appellate lawyer who has that experience at a high level, is often more sensitive to words and phrasings and to documents contents that might be to caricaturize a little bit, but more of a shoot from the hip trial attorney who spends his days, in a rough and tumble courtroom. And is it fair to say that you were more of the former and more? So I would push back. I think that's not respecting the talent of the trial lawyer, and particularly on these types of agreements or documents. There are folks that sort of have expertise, because even if this was sui generis, they would have seen a lot of this. I am not suggesting that redacted, Lori, right? We're not up to this. Right? Because certainly she also had a lot of appellate experience. I'm simply noting that this seems to be sort of in your wheelhouse. I apologize whether I'm not sure what is in my wheelhouse means. I'm pretty sure he knows what that means. I appear to have read this. I suggest some edits as I would have approached this document. My assumption would have been I'm looking at it from earlier concern, that the policy level concerns. Does it capture that we're deferring to the state, going back to Going back to the put in the petite policy versus not, the wording, man. Does it capture the policy concerns of appropriately understanding that we can't force the state to do something? And does it capture the essential elements of the terms that we had looked for? The all right. You know, the imprisonment, registration, and restitution. All right. So one of the things that is a little striking that's different from the original draft MPA, even as amended by you. So let's pull out the 16B. Is what I would call the non-admission of guilty. So in the first page of 16B, the first paragraph, that's the first clause after the 1 through 5 statutes listing in 16B reads, it appears that Epstein has accepted responsibility for his behavior by his signature on this agreement. I'm sorry, you're on 16B? 16B. Okay, it appearing yes. Okay, so his is, and this is not, this seems to be fairly typical sort of plea agreement language, right? Yeah. And if you look at the top of the final MPA 22 the 3rd, appearing clause. I'm sorry, where? Fine. Where are you? 16B, right. Has the 3rd it appearing? He has the down at the bottom. Yeah. It says refers to it, It says refers to at the, it has accepted responsibility. Second up, yes, exactly. He's accepted responsibility. Right. And then above in the 4th, it appearing, yeah. The wording, it references the fact that it appearing Epstein has committed, it should say, it's apparent Epstein has committed offenses against the United States. Yes. Okay, so there's a sense of acceptance of responsibility in the final MPA, which is 22 in your right hand, the right. 3rd, it appearing clause says nothing about Epstein committing offenses. It simply referenced the U.S. Attorney's Office and the FBI having conducted their own investigation into Epstein's background and any offenses that may have been committed by Epstein, including, right, the enumerated statutes, and then following the enumerated federal status, there's no reference at all to Epstein accepting responsibility. Do you view that the removal of that acceptance of responsibility to be something that was appropriate? So trying to reconstruct the focus on, and I know I'm repeating myself, but jail time, registration, restitution. Whether he accepted responsibility for a federal or for a state, I think my focus would have been on these were the terms. Does this encompass those terms? So as that concession is not something material, as far as I don't want to use the legal term material, but it wasn't important. So to your objectives, so is that right? First, I'm not sure. So it wasn't a concession from that those 4 bullets, right? It was a concession from an earlier draft, right? And so to say it's not important, again, there was an early draft. It changed. The focus was in any give and take drafts changed. The focus was, did he go to jail? Did he have to register? Did we have restitution? Now, he said this a billion times. He's going for the bare minimum, and that seems to be why he's getting drilled by the person asking the questions, and he's brushing out every single time. So he says, right. And so to say it's not important is, again, there was an early draft. It changed. The focus was in any give and take drafts changed. The focus was, did he go to jail? Did he have to register? Did we have restitution? All right, by redacted. I repeated that because I had to come back and redraft this. So it's funny how they're talking about an earlier draft. This is the later draft. Do you remember noticing that change and thinking it? Just doesn't matter. I don't. In all candor, until right now, I was not aware of that change. I doubt I would have taken 2 documents and sort of put them side by side as opposed to, does this capture what we're trying to get to? By redacted. So does that? I was aware of the 24 to 18. But up until this question, I wasn't aware of that change to my recollection. So, and you're aware of the 24 to 18 because you noticed it in the MPA or because somebody told you separately. Do you know? Or do you know? So basically, he's not even, he's basically questioning if he even knew that he had a reduced sentence from the 2 years that he mandated down to something less than 2 years, or did he just sign stuff? I wish I really knew the name of this individual that was asking the questions. I can't say other than I was aware. So basically, he probably didn't even know about it. Acosta's given these very vague answers, which basically shows he was not very involved. And in some of the news coverage in the media that I've seen, he's actually said, and you can go research it yourself, that he was told that he was untouchable, that he was some sort of government asset or something like that, and that basically they wanted to put him back into play. In the final MPA on page 5, there's a series of things that are included at the bottom of that page in that long paragraph, and the one that I want to focus on is the immunity portion. That was certainly not in the original draft proposed by the U.S. Attorney's Office. In this paragraph, the United States agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to tons of redactions. Did you notice that provision? This is an excellent place to end this episode, because we've all been wondering, why has there not been any consequences for the actions that took place? And if this was in writing that there was to be no action taken against any of the people that were involved in this, we obviously would want to know why. And this is why we're reading these files. We need the answers because it simply does not make sense. For my true detective sleuths who made it through this episode, like I said, once again, this is another kind of files that we're just being introduced to. And this is very, very heavy. I mean, you could even consider it a little, it's dense, but I don't want to call it dry, but it's definitely wordy to the point where you would actually have to pay attention to all of the layers to pick up what's being said here, and the level of scrutiny that this person that's talking to Acosta is giving him. And to discover this last portion about there being paperwork drawn up and proposed to not charge any of the co-conspirators of Epstein. If they helped facilitate the crimes, why would they not be charged? So I'm sure we're going to find out more answers to that as we continue. But this is the end of the episode. It's file 9100. So we're going to end it here. And it's a rather lengthy episode, so I'm not going to keep you guys too long. I've been looking at the analytics, and I think we're up to like 43 to 45% of my daily viewers being subscribed. So if you're not, please do me a favor, because like I said, I put a lot of time, effort, and hours into this channel. So the least you could do is take 2 seconds to click the subscribe button and the notification button. It's the little logo that you'll see on the end screen at the end of the video. You just click it and then click subscribe. Literally, it's 2 clicks, and it would be appreciated, because I think we should at least be at 60% of viewers subscribe. But not to beat a dead horse, you know, we want to get awareness to this, so I appreciate it if you guys hit subscribe, and it definitely validates the efforts. And aside from that, more importantly, make sure you share this information. Lots of people don't know that anyone's reviewing this, or that this is even reviewable. You know, every day I'm seeing comments of people who've fallen upon our channel, my channel, and they're very grateful. You know, they say, hey, this is exactly what I was looking for. This is the breakdown that I was hoping to get, because some people just don't understand this material or even how to navigate it. So I'm happy that I'm able to provide that and give some more context to what's initially a very confusing topic and file setup. So, but with that being said, I'm not going to hold you guys any longer. It's been a long journey this episode, so I will see you guys in the next episode, which will be episode 92. We're working our way towards triple-digit episodes, and that episode we will be covering files 9100 through 9200. As always, if you have any questions, comments, or anything to add to the context of the conversation, by all means, put that in the comment section. You know, you guys know I'm really good about responding to your comments, the things that you point out, and all of the intricacies that you guys can put together. And that's what makes this channel beautiful. It's all eyes on, you know, on the pages, and all hands on deck, which allows us to break these codes down a lot faster, as opposed to just doing it by yourself. But enough of that. It's been a great episode. I can't wait to get into the next one to get more into context of the last question. So I will see you guys in the next episode, episode 92. You guys take care.